Good morning. Thank you for joining us for this joint committee between the Committee on Judiciary and the Committee on Public Safety, Intergovernmental and Military Affairs on this Tuesday morning, 9:30 in room 016. We have one measure on the agenda, but I'm sorry, before I get to that, I need to make a few housekeeping announcements. This meeting is being streamed live on YouTube. In the unlikely event that we, for some reason, have some technical turbulence and take a nosedive, this committee will reconvene at 3 o'clock tomorrow, Wednesday, February 15th. A public notice will be posted on the legislature's website. As a reminder, we have a time limit of 2 minutes per testifier, and I'll be reading off a list of individuals who have indicated their desire to testify. So we are on Senate Bill 1527 relating to address confidentiality. First on our testifiers list, we have the Lieutenant Governor, Sylvia Luke.
Good morning. You have our written testimony, so we stand on our written testimony, but we'll be available for any questions. Thank you.
Thank you. Michael Vincent from the Department of Law Enforcement.
Morning, Chairs Rhodes and Wakai and Vice Chairs Gabbard and Elefante. You have a written testimony. One of the things that came up on the companion measure when it was heard in the House was the authority given for the use of a third party was broader than we anticipated. So we have some suggested language to clarify that the use of a third party is going to be limited to basically the address forwarding aspects and possibly the service of process. So we've got some suggested language in our testimony for that. And I'm available for any questions if you have any. Thank you.
Thank you, Mr. Vincent. We have Angela Mercado from the State Coalition Against Domestic Violence. Mercado joining us via Zoom.
Yes, good morning, Chair, Vice Chair, committee members. Angelina Mercado, Executive Director of the Hawaii State Coalition Against Domestic Violence. On behalf of our 28-member program statewide, we have submitted written testimony, stand on that testimony, and are available for any questions you may have. Aloha.
Thank you, Angela. That's all I have for individuals indicating they'd like to testify. Is there anyone in the room or via Zoom that would like to speak on Senate Bill 1527? If not, members, any questions? You want to just vote? Sure. Okay.
You guys have quorum?
Oh, sorry. Yeah, I forgot about that important aspect of it. We're going to recess quickly before we take our vote. Thank you for your patience. We're reconvening the Joint Committees on Judiciary and the Committee on Public Safety, Intergovernmental and Military Affairs for decision-making on Senate Bill 1527. The two chairs have conferred, and we'd like to make 3 amendments to this measure, all based on the Coalition Against Domestic Violence's suggestion. So we'll take amendment or recommendation number 1, deleting lines 4 through 7 on page 1, for contracting out for administrative services. Both chairs feel that this really should be something that is fully functioning based on government employees and not have a private sector entity overseeing this sensitive information. On the second recommendation is to establish a confidentiality governance committee to advise the Department of Law Enforcement as it implements this new program. And third change will be to make the effective date in Section 8 of this bill to January 1st, 2024, rather than upon approval. So those are the 3 suggested amendments to Senate Bill 1527. Members, any discussion? If not, Senator Elefante, I vote yes.
Okay, Chair's recommendation is to pass SB 1527 with amendments. Chair votes aye, Vice Chair votes aye. Senator Fukunaga is excused. Senator McKelvey.
Yes.
Senator Awa is excused. Mr. Chair, the measure passes with amendments.
Thank you.
Thank you for JDC members. Same recommendation. Any questions or concerns? If not, Vice Chair.
Recommendations to pass SB 1527 with amendments. Chair votes
Aye.
Vice Chair votes aye. Senator Elefante.
Aye.
Senator Bonaventura is excused. Senator Awa is excused. Measure passes.
Thank you.
Thank you. Happy Valentine's Day. We're adjourned.
Good job. See you.
Okay, welcome everyone to the next agenda of the Judiciary Committee. It's our 9:35 agenda. Let's see, if we have a catastrophic technical failure, we will reconvene on Thursday the 16th at 10 a.m. here in 016, and a public notice will be posted on the legislature's website. We do have a 2-minute time limit for testimony, both in Zoom and in person. And if you're on Zoom, then your video will be turned off and you'll be muted until it's your turn to go. There is a countdown timer on the Zoom screen, and I think we'll have a button that goes off for those in the room so you know when your time is up. Okay, so the 9:35 agenda is one bill, SB 34, and I think because the introducer of the bill is on the committee and would probably like to be here, I'm gonna recess this hearing, the 9:35 hearing, until he arrives, and then we'll go on from there for SB 34. Let's see, what time is it? And I'll just go ahead and recess because our next hearing is not till 9:40, so short recess. Welcome back to the Judiciary Committee. This will be the 9:40 agenda until the sponsor of the SB 34 comes back for the 9:35. On the 9:40 agenda, there are 4 bills that have to lateral by Thursday. So I'm going to take 3 of them out of order. And do those first, just in case we don't make it to the end. So my apologies for those of you who are testifying on SB 179, 182, 805, 197, 226, 228. You'll be at the end of the agenda or after the ones that we have to lateral. And since Senator Waugh is here, we'll go ahead and recess the 9:40. And we'll go back to the 9:30, the 9:35. So going to the 9:35 agenda, so recessing the 9:40, going back into the 9:35. The real property that they own. Continuous period of 365. Bill makes no mention. Okay, there are 4. Okay, that's it. First up on SB 34 is Gary Suganuma for the Director Department of Taxation. First designee. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. My name is Denise Inouye, and I'm here on behalf of the Department of Taxation. Thank you for the opportunity to testify. The department stands on its written testimony in providing comments on this measure, and I'm available to answer any questions you may have. Thank you.
Thank you. Next is Tom Yamachika for the Tax Foundation of Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We have submitted testimony in the proposed Senate Draft 1. Will stand in our written testimony and be available for questions.
Thank you very much. Next is Evan Owe, testifying for Jennifer Camp, NAIOP Hawaii. Doesn't appear to be here. In opposition. Okay, then after that we have the rest of the page is individuals in support. I don't know, probably 20. Oh, I'm sorry, 1 opposition. And then on the second page we have Natalie Owasu with comments, and then we have 4 other individuals all in support. That is all the people who have signed up for SB 34. Does anyone else wish to testify on SB 34? Seeing none, members, questions? Okay, well, let's go ahead and go on to decision making on this one since this is a separate agenda. The recommendation here is to go ahead and pass it out with a delayed effective date of March 22, 2075. To keep the conversation going. There are some issues with the bill. There's some blanks still, so those would have to be worked out at the very least. But I'd like to keep it alive for another round if that's okay. Any comments or questions? If not, Vice Chair for the vote.
Chair's recommendations to pass SB 34 with amendments. The members present, are there any no votes or reservations? Hearing none, the measure passes.
Okay, thank you very much. So that ends the 9:35 agenda. I know, Mr. Older, you want us to count down again, but let's just go straight into the 9:40 agenda again. This is what we would have done pre-Zoom, and I think the people on Zoom can understand what's going on. So we're back in the 9:40 agenda. Okay, first up on the 9:40 agenda is SB 495. This extends the time each county has to amend and adopt the Hawaii State Building Codes from 2 to 6 years. First testifier on SB 495 is Mark Glick, Chief Energy Officer. Good morning.
Good morning, Senator Rhodes, Gabbard, committee members. I am Howard Wig here on behalf of Mark Glick, Hawaii State Energy Office. We oppose this bill. We know the intent, but it would set back the code adoption process on all codes significantly, and in particular, the energy code. We lead the nation in heading towards zero net energy economy. Japan is looking to us for leadership, other states looking to us for leadership, and this would set back our path to a clean economy significantly. Likewise, with the other building codes, they're updated every 3 years for a reason. And we only need to look at Turkey to see what happens when you don't comply with your building codes. And technology is continually improving, and the codes keep up with that improving technology. I'd be glad to answer any questions. Thank you.
Okay, thank you. Next up is Al Itamoto, Executive Director, Electrical Contractors Association. Good morning.
Good morning. Thank you, Chair Rose and Vice Chair Gabbard and members of the committee. I'm Al Itamoto with the Electrical Contractors Association of Hawaii and NECA Hawaii chapter. I submitted written testimony and submitted that yesterday in opposition. And I'd like to just add a few comments. I brought along with me the code book. This is the 2020 code book. It contains over 1,300 pages cover to cover, and it includes all of the installation and the electrical guidelines that's necessary for electrical work in Hawaii. Also, I brought along from the Electrical Contractors magazine produced by the National Electrical Contractors Association of the significant changes that will be incorporated into the 2023 code book. And these changes include 25 changes to the 2020 National Electrical Code. So what we're looking at is it will seem excessive to allow an additional 4 years for the counties to review and to adopt or amend their individual county code. Because basically all they need to do is to look at these 25 code changes. Okay. Secondly, with the Hawaii's goal of becoming 100% renewable independent by 2045, which is only 22 years from now, the electrical construction industry would be to perform the majority of that work to get to that goal. And the standards and the installation methods must be kept current in order to incorporate all of the new changes and new technology involved with all the equipment and fixtures to get to our renewable energy goal. And so in our opinion, the 6 years is excessive. It's not necessary. And so we ask that either this measure be deferred or be amended to exclude the electrical code.
Thank you very much.
Thank you.
Next is Greg Sirikaku, Executive Director for PANCA. With comments, next is Evan Oe for NAIOP Hawaii. in support. Next is Melissa Miyashiro Blue Planet Foundation. In opposition, Stephanie Sakamoto for BIA Hawaii. In support, okay. And Andrew Crossland in opposition. That's everybody who signed up for SB 495. Anyone else wish to testify on SB 495? Okay, seeing none, members, questions? Senator Elefante.
I have a question for Mr. Itomoto. Hi, Mr. Itomoto. Thank you for being here and thank you for your testimony. I read through your testimony and I understand your opposition to increasing it from 2 to 6. You did mention in your testimony that every 3 years you would have to renew your license. So would you be opposed to going up by a year or 2 years, or are you comfortable with how the law is now? Because if you have every 3 years, I would imagine.
Yeah, we're comfortable with where the law is now because the state will not adopt necessarily on the code change date. So in other words, the 2020 code was not adopted in 2020.
Right.
So sometimes it takes some time
Right.
for that to be adopted by the state. So if you add another 2 years to that, you'll be into another edition of the code.
Right. Okay. Thank you.
Does that explain?
Yeah, thank you, Chair.
Thank you. Members, other questions? Mr. Glick, are you still here?
Howard Wade, State Energy Office.
Do you know what the rationale for the current time frame for counties to adopt the state building codes, which is 2 years? Why would it?
Yes, there is a national policy of updating codes every 3 years. And the way the code adoption process works is first it passes at the national level, then it goes down to the state level. And in Hawaii, from the state level, it goes down to the county level. And so we've done 2 years for the first phase, 1 year for the next phase to keep it in sync with the federal timeline.
Okay, so you don't give the counties 3 years because it takes a while to get to that point. Is that what you're saying?
Yes, yes.
Okay. So what is the intent of your amendment? Is it a workaround to allow the counties more time to adopt an updated building code?
We had a big issue at the last hearing from Mayor Roth. Mayor Roth himself called in, and then he called a personal call to myself and my superior, and he said, the Big Island is having one heck of a time complying with the codes, and our corp council is unclear as to when the code must be adopted and if the county has the authority to amend the code as it sees fit. So we stuck this amendment in to make it crystal clear that yes, the counties do have the flexibility.
Okay. All right, but, okay. But you're opposed to the bill overall, so you view, even with that amendment that you're proposing, you prefer that the bill not advance?
Absolutely,
Okay, all right.
because we need to keep up with the 3-year cycle.
Okay. Other questions,
Yeah,
members?
I-
Senator Bonaventura.
Okay, sorry, I guess you're on the hot seat. So here's my question. And I'm not sure because I'm not a contractor.
Sure.
But I do know, like, on my county, there is like, it takes forever to get a building permit. Sometimes over a year or so. My question is, if it takes like over a year to get a building permit and the code changes, so do we need to keep like amending the building permit to show different plans to ensure that the code is satisfied, or how does that work? I mean, I could see the utility of having the 6 years because it gives contractors who have to wait 1 to 2 years for a building permit some kind of certainty as to how much materials to buy, what, how do we give them that certainty?
Once the plan is certified or permitted by the county building department, that is the code that you follow. Even if the rest of the process takes 2, 3, 4, 5 years, you are authorized to proceed with that particular code. And let me say also
But if it takes like 2 years to get that, then you have a new building, then you have new building codes. That's the problem I'm seeing.
Yeah. And we totally acknowledge that. We work with the counties very closely, and the best phrase I've heard from the counties is, Howard, we do not have the bandwidth to keep up with these codes.
Yeah.
And what we've been doing is working with HIEMA, the national or the local branch of FEMA, and they very much want the counties and the state to keep.
Sorry to interrupt. Can people in back here? No, can you pull the mic, just pull the mic physically closer to you? Thank you.
Okay, yes, I can hear you.
Yeah, okay.
Thank you. Yes, the counties do not have the bandwidth to keep up with the latest code. So HIEMA is who very much wants the codes updated, because that includes the structural codes to guard against disaster. They say, we have the funding to help the state and the counties.
But that doesn't answer my question. How do we give contractors, and in my district where we have a lot of owner builders who don't even keep up very well, okay? How do they give them the certainty that when they put in for a building permit that doesn't get approved until 2 years later, that they don't have to redo their plans to keep up with a new code?
I'm afraid they have to update the code in that case.
Oh, they have to turn in new building permits. Okay.
Totally acknowledge that is not their fault. It's just the slow process of government. But again, with this new funding, we're hoping to get the counties a lot of help so that they can keep up with all the codes.
Okay, thank you.
Okay.
Thanks, Senator Elefante. Go ahead.
Can I just add, and maybe this will give some background context to my fellow colleagues. Thank you, Chair, for hearing this bill. When I was at the county council, this is an issue. We worked with Mr. Wig and your office and different stakeholders. But what I heard from the industry was we would be voting on an old building code from years ago and not be up to date, and so it would be behind. So I can understand the concerns of health and safety, but voting on an outdated but not getting certainty, as my colleague Senator San Buenaventura mentioned. So I'm open to, 3 years could be a possibility, Chair. I don't know what your intent is to do, but to give a sort of a certainty to the industry, the building industry, so that they're not having to come and learn new. But I do respect your comments and understanding where that is. But health and safety is one thing, and that should be the most important. But when I was at the county council, we would be voting on backdated building codes, and a lot of the folks applying for applications wouldn't know specifically which code to follow or what would be the law. So that is sort of the reason why I introduced it. So thanks, Chair.
Yeah. So I do have a question too. So, I mean, the sort of picture illustration of, here's the code, here's what changed. How significant are the changes from code to code?
I can speak to the energy code. We'll be following the Honolulu Code, Bill 25, we remember it well, to include PV ready and EV ready provisions in the 2021 Energy Code. Those are the significant changes right there, and the counties are free to not include those provisions if they see fit.
Let's see. Okay. All right. Thank you. Other questions, members? If not, we'll go ahead and move on. Thank you very much. Thank you all for being here on this one. Okay. As I mentioned before, we're going to skip, my apologies for those who are here for the JDC only ones. We're going to put those to the end of the agenda because we have to lateral the others by Thursday. So the next one, it says it's a JDC single on the agenda, but it has been re-referred since we posted the notice, and that's SB 977. Now I will have to find it too here in just a second. Okay, SB 977 relating to the judiciary as introduced allows for judicial review of orders fixing minimum terms of imprisonment. We post a proposed SD1 and we have a part 2 that specifies in any civil action brought by a petitioner seeking compensation of any kind or nature whatsoever as a result of or related to or arising from a conviction and imprisonment for crimes for which the person was actually innocent, any recovery will offset dollar for dollar the total award made in the civil action against whom claims are asserted. The recovery being under chapter 661B. Okay, first up on 977 is Randy Canal, ICA Supervising Staff Attorney.
Aloha, Chair Rhodes, Vice Chair Gabbard, and committee members. I am Randy Canal, the Supervising Staff Attorney at the ICA. Thank you for allowing me to testify today. The judiciary opposes the bill, not the new offset provision, but the other parts of the bill, because the existing Rule 40 process already allows an inmate to seek judicial review of an HPA minimum term order, and the changes that are proposed by the bill would cause confusion and significantly impact judiciary resources. Rule 40 process is not as burdensome as the bill portrays, and the bill actually provides fewer procedural safeguards for inmates. And those are all laid out nicely in Judge Kawamura's written testimony, which I won't repeat here. But I do want to emphasize that in the last fiscal year before the pandemic, the HPA set over 2,000 minimum terms. And under this bill, every single one of those orders could be reviewed in the circuit court. And the circuit court's decisions could then be appealed to the ICA, which could result in hundreds of new appeals each year. And the reason we predict such significant impacts to our caseload is because the standard for seeking review under this bill is so incredibly low when compared to the Rule 40 petition. Under this bill, all the inmate has to say to the circuit court is, please review our minimum term proceedings, or the HPA's minimum term proceedings. That's it. It literally could be one sentence. The only requirement is that it be filed within 90 days after the HPA order. They don't have to state a claim or state any supporting facts like they have to do under Rule 40. And with such a low, almost non-existent threshold for the process proposed by this bill, it's going to result in a lot more work for the judiciary in both the trial and the appellate courts, and effectively nullify the gains from adding a new ICA judge last year. And the last point I want to make is that it seems the focus of the bill is a perceived lack of a right to counsel after the minimum term hearing. Just because there's no express right to counsel in that situation doesn't necessarily preclude the public defender from representing inmates after the minimum term hearing, as attorneys can file Rule 40 petitions for inmates. But in any event, we oppose the bill as it's currently written, but we agree that perhaps it would be better for the inmates and the courts if the inmates were represented in Rule 40 proceedings that challenge the terms.
Thank you very much. Next up is Judge Shirley M. Kawamura for criminal, she's the criminal administrative judge. Or her designee. Oh, with comments, sorry. And next we have Fred Hume, Chair, Hawaii Paroling Authority.
Stand on our written testimonies in opposition to.
In opposition, okay. Next we have Ben Lowenthal for the Office of Public Defender.
Good morning.
Morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, committee members. This is Ben Lowenthal. I'm appearing on Zoom this morning. I'm a public defender assigned to the Maui office. Also, the public defender, James Tabe, is available for questions. We stand on our written testimony. We believe that this will allow public defenders to file the motion in the original case from which the inmate was sentenced, so that they do not have to go at it alone from within a prison to file a Rule 40 petition without the assistance of their own counsel. I know that there is opposition testimony about raising concerns about efficiency in the courts, but frankly, there is a hidden cost. There is a cost with the current system now with the Rule 40 petition. Right now, if a Rule 40 petition is denied without a hearing, that is an automatic appeal in which counsel would have to be appointed and argue in front of the ICA, contributing to the ICA burden. And if they prevail there, it simply goes back down to the circuit court with the instructions to set a hearing. There's a full-blown evidentiary hearing, in which case there's a whole second round of appeals. For minimum term orders, it gets rid of that. It creates one motion with paper review, no evidentiary hearing. It will actually cut down on the backlog in the ICA. And it would also, frankly, allow representation to continue so that it can go back to the judge that rendered the sentence, who is familiar with the case and with the defendant and with the attorney. And it will not only continue representation for the indigent, it would also streamline measures. It should cut down on the number of Rule 40s. Thank you very much.
Thank you. Next is Kenneth Lawson, Co-Director, Hawaii Innocence Project. Good morning.
Good morning. I really don't have too much to add. My comments are going towards the amendment of the exclusive provision or exclusivity clause in the wrongful conviction compensation statute. And the reason for that is we believe that those who are actually innocent should also have the right to pursue civil rights violations, especially in cases where there could be intentional misconduct. Right now, the way the bill reads, the current bill, is it makes the compensation statute the exclusive remedy, and not allowing an individual who's actually innocent to pursue civil rights violations or other state law claims. However, somebody is actually guilty and believes their civil rights have been violated, they're not limited in their ability to pursue these matters. So, and we do believe the offset provision allows, as I stated in my testimony, federal civil rights lawsuits hold bad actors accountable and incentivize agencies to make changes to prevent future wrongful convictions. The civil offset provision allows the state to recover money if an exoneree wins an award or settlement from the entities that are actually responsible for the wrongful convictions. The offset provision is a more fiscally responsible option than barring civil lawsuits. So with that, I'd ask that the bill be amended, or at least Chapter 661B be amended to allow this offset provision. Thank you.
Thank you very much. Next, we have Hawaii Association of Criminal Defense Lawyers in support, William Karen in support, William Harrison in support, Virginia Hinch in support. Anybody's here want to speak, let me know. And that's all, that's everybody who signed up on SB 977. Anyone else here to testify on SB 977, Zoom or in person? Okay, if not, members, questions? Mr. Pennell, if you're still there, a question for you.
Yes.
Okay. So with getting sort of conflicting testimony on how the process works now, can you just briefly describe from judiciary's perspective how the process works?
Sure.
For part one of the bill on the paroling authority part.
I keep getting. Can you folks hear me?
Yes.
Okay. Yes. It's laid out in detail in Judge Kawamura's testimony, and so I'll try to summarize. But what happens is, if the sorry, I'm getting pop-ups. The circuit court, if the circuit court finds a Rule 40 petition states a colorable claim, then it would appoint counsel. So after the HPA minimum term hearing occurs, the inmate can file a Rule 40 petition. If the circuit court finds that petition states a colorable claim, then the circuit court will appoint counsel. If it doesn't appoint counsel and then the petitioner appeals, the petitioner can ask the appellate court to appoint counsel. And usually when the circuit court appoints counsel in a criminal case, the order appoints counsel for that case and the appeal. If the time to appeal has expired, usually it's 30 days, and there's no appeal, then the representation ends. The HPA minimum term hearing usually happens several months after sentencing. So by then, if there's no appeal, then the defendant doesn't have counsel. If the defendant wants counsel for the minimum term hearing, they request it through the HPA, and then the HPA submits that request to the circuit court, and the circuit court appoints counsel for purposes of the minimum term hearing. But sometimes a defendant terminates counsel after the conviction and judgment, files a notice of appeal self-represented, and appears at the minimum term hearing self-represented. So this bill doesn't ensure that counsel will represent a defendant who seeks judicial review of HPA minimum term proceedings.
How does a petitioner know to do all this?
They're presumably consulting with their counsel after the minimum term hearing, and they discuss what their options are. That has been Mr. Tabe's testimony in the companion bill, HB 862.
But you're saying then that the attorney that represented the petitioner during the criminal trial, they do stay over sometimes?
No.
No. It is the attorney that's representing the defendant at the HPA minimum term hearing would consult with that defendant after the hearing and explain their options. And many times the inmates.
Oh, sorry, but I'm sorry. I'm just trying to figure out the procedure here. So if you're in a criminal case, say you're defended by a public defender, which is pretty common. You lose. The judge gives the indeterminate maximum term, and then you go to the paroling authority for I forget what the technical term is, minimum, maybe the maximum minimum term, or anyway, there's a step that the floor is set by HPA. Is that still the public defender that's with the person at the HPA?
It depends. If no notice of appeal has been filed, then the public defender is no longer representing the defendant in that direct criminal appeal, and the HPA hearing happens months later. So it could be somebody different. It could be the public defender. The HPA sends a notice to the court saying, we have a minimum term hearing coming up. The defendant wants representation. Circuit court, please appoint counsel. It could be the public defender. It could be somebody else.
Okay, so then for the amendment that you suggested, the judiciary suggests, which is, let's see if I can find the language here, hang on. That will allow the incarcerated person who was previously represented by counsel to continue to have the right of representation for properly filed petitions concerning their minimum term of imprisonment. Does that mean you still have to switch attorneys, or is that likely the outcome?
No, I think we're all on the same page. It's going to be beneficial to have counsel. Our proposed language is narrowly tailored to those situations where the inmate has counsel at the HPA hearing and provides the 90-day deadline. It basically says if you had counsel at the HPA hearing, then you get counsel on judicial review of the HPA order or proceedings. It essentially maintains the status quo for the post-hearing proceeding of Rule 40 petition challenging the minimum term order.
Okay, Mr. Lowenthal, are you still there?
Yes.
So I'm still not quite sure I understand how it. So what do you? How do you read it? Did you have a chance to look at the judiciary's suggested amendment?
I have. There are a couple of problems with the status quo, so to speak, which is why we are in support of the bill. And if I may, Senator, I can try to explain the procedure, at least from the public defender standpoint.
Well, I guess at this point, is it your understanding that the attorney representing a defendant at HPA would carry over to the appeal under their amendment, or are you arguing that that's not what would happen? Sure.
What is happening now is after the sentencing, the attorney who represents the defendant at the sentencing, the public defender's office, will continue to represent, or should continue to represent, the inmate in front of the parole board when the parole board determines the minimum term. If something goes wrong, or if the attorney believes there's an error that was committed at the parole board, the only remedy is to file this Rule 40 right now. And the problem with that is that's a separate cause of action with a separate case number. It is quasi-civil with a filing fee, and there is no right to counsel in filing the petition. So that means public defenders have to advise their clients, some with limited education, many aren't lawyers themselves, to write this up on their own and hope that the judge will set a hearing and appoint counsel, which typically would be the public defender again. But that's why this bill would fill this gap. And so I hope that answers the question or at least clarifies the need for this.
So, but then in relation to the judiciary's proposed amendment, do you believe that their proposed amendment actually fixes the problem by allowing the person who was previously represented by council to continue? I mean, all they're saying is to continue to have the right, but
right. It doesn't fix the problem, respectfully, because it still links the challenge to a minimum term order with a Rule 40 petition. It's not just the minimum term order. A Rule 40 includes all kinds of issues: ineffective assistance of counsel, whether certain evidence was used at a trial, all kinds of issues. And by saying, well, for 90 days, you have this right to file any Rule 40, it's oftentimes, that would include all of the other issues, because if you don't raise it, then it could be waived down the line. And so it really doesn't remedy the problem. And as a matter of fact, it may even result in more Rule 40 petitions that the judiciary is concerned about.
okay, thank you. Members, other questions? Okay, Senator Elefante, go ahead.
Question for this person right here. I can't really see your name. Lowenthal. Hi.
Hi.
How many clients would you say fall into this predicament that you are experiencing now?
I would say, and that's another benefit to this, is that in representing our clients, we can sit down with them, talk about their options, and assess whether there was an error solely by the parole board in determining the minimum term. There may not be a lot, but when there are, we can file the motion. So I would say, I can't give any statistical information or numbers, but I would say whether there is an error by the parole board would be based on what happened at the hearing. And frankly, the language also is akin to an agency appeal. The circuit court, in reviewing one of these motions, would have a lot of deference to what the parole board did. So in attempting to answer your question, Senator, I would say, it's not simply saying I want a carte blanche review. The circuit court would have to determine whether there was a legal error or a factual error, and there is a lot of deference to the parole board. And so I don't believe there would be a lot of these types of challenges. I don't have those numbers for you.
Thank you, Mr. Lowenthal. Thank you, Chair.
Other questions? Senator San Buenaventura.
You know what? I'm going to waive my question.
Okay. Okay, so Mr. Lowenthal, if instead the amendment, if instead we amended it just to say that the HPA hearing and any appeal from that would be considered the same criminal, is considered part of the same criminal case, does that address your concern about continuity of representation?
I don't quite, if you're suggesting the language that's proposed by the judiciary, so that it's simply another Rule 40 or there's representation in filing of the Rule 40, no. The whole reason for it is because the original case, the criminal case, there needs to be continuity in that. And this would allow the filing of a motion in the original criminal case instead of filing a brand new lawsuit, which is what a Rule 40 petition is.
Yeah, okay, all right. Mr. Pinal, are you still there? Why couldn't we just make it all, why couldn't the HPA hearing and any appeals from that be all part of the same, all part of the original criminal case, just a continuation of them, and whoever was representing continue on?
I'm going to have to defer to Judge Calamara's comments. She's more well-versed in the impacts directly to the circuit court. I can provide the answer to that question in written test or in writing to the committee as soon as this hearing is over. Okay. But I'll just leave it at that. I don't want to misstate.
Okay, that's fine.
Chair,
Yes.
I think I can sort of answer your question.
Okay, go ahead.
And you can correct me if I'm wrong, because I have been an attorney who has been appointed in Rule 40 cases. So the reason why is because you need to have a final judgment. And if there is a notice of appeal, the circuit court loses jurisdiction of the underlying case. So when they do a Rule 40 petition, it becomes a new case. Isn't that right? Is that your understanding?
That is true. And once the judgment, I'm sorry.
Go ahead.
Once the judgment is filed in the criminal case, the circuit court loses jurisdiction to do a lot of things.
Yeah.
So it's not clear from the language that's in the current version of the bill whether the trial court would even have jurisdiction to entertain the motion that's being proposed.
Okay. I mean, does it have to be that way, or is that just logistical? I mean, is it a rule that can change? I mean,
there's a whole body of law if you're going to change that.
Okay, Mr. Hume, you had something you want to say? Morning.
Good morning, Chair, committee members. I just want to add some clarity to the hearing process. So last year, the Hawaii Paroling Authority conducted over 1,300 minimum hearings for 861 inmates, okay? Previous to that, as the judiciary indicates, we held over 2,000 in fiscal year 19. So there are quite a number of hearings that the parole board does conduct, and each time an inmate is sentenced, the parole board conducts a minimum hearing within 6 months of their arrival date into the facility. So that's quite a load, as well as preparation when you look at the board having to study the levels of punishment and the documentation submitted. Inmates, we generally highly recommend, and at least over 98% of the cases are represented by legal counsel, whether it's public defender, court-appointed, or retained counsel. So they are properly represented. Now, what also complicates matters is when you have lately, the court imposes mandatory minimums, especially on repeat offenders. So the board cannot go below a court mandated minimum, but it can go above based on the history and how it reviews each case, especially for repeat offenders. So.
Okay. All right. Thanks very much.
Okay. Thank you.
Other questions? If not, I've spent too much time on this bill already, so we'll go ahead and move on now. As I mentioned before, we're going to do the ones that are JDC AMA WAMs before we do the JDC single. So the next one up will be SB 669. SB 669 is would establish regulations for the cultivation, sale, and personal use of small amounts of cannabis, decriminalizes and regulates small amounts of cannabis for personal use, and establishes taxes for cannabis sales. First up on 669 is Gary Yabuta, Executive Director, Hawaii High Density Drug Trafficking Area. In opposition, Andrew Goff, Deputy Attorney General for the Attorney General's Office. Oh, you're here. Good morning.
Good morning, Chair, members of the committee. Andrew Goff, the Attorney General's Office. I would note that our office opposes this bill on law enforcement grounds. And just to be clear, it's not law enforcement against consumers, but every well-regulated state cannabis program needs protections against diversions, unregulated products, and protection for minors. This bill would remove cannabis completely from the State Controlled Substances Act, which is currently the law enforcement control, or one of the law enforcement controls of cannabis. Law enforcement agencies like the Narcotics Enforcement Division assist with even the medical cannabis program in controlling unlicensed distribution and manufacturing of cannabis. And if it's removed from the CSA, then there will no longer be law enforcement controls. And the regulation would be basically limited to regulatory and criminal penalties that will be administered by a regulatory agency. And we also have some concerns that we note in our testimony on the penalties. The rulemaking authority gives the agency the ability to make civil penalties. That's a fairly broad authority. We would ask that that be enumerated and at least fines be allowed to be levied. And then just for clarity's sake, that we can revoke, suspend, or otherwise constrict licenses. And also there is no tracking requirement, which is the cornerstone of any well-regulated state cannabis program. We also do note several other inconsistencies with the laws in the testimony. Laws, as Kauai has an anti-smoking law, 328J. It's not really clear whether that would conflict with that law. And it's not really clear whether the land use laws or zoning ordinances would be still in effect. So I'm happy to answer any questions you folks have, and we'd be happy to work with you in any amendments.
Okay, thank you. Next up is James Tabe, Public Defender. Good morning.
Good morning. Good morning, Chair, Vice Chair, members of the committee. James Tabe, Public Defender of the State of Hawaii. We do support this bill. Basically, the marijuana market already exists. Problem is, it's unregulated. The sellers, they don't pay taxes. They don't check ID. They don't test for purity. It's basically, they sell it without labels, without any condition. What this bill would do is basically, regulate this market. I mean, that's basically what we want to do. We acknowledge that, first of all, I do want to point out that we're not supporting this bill because marijuana is not harmless. It is because it's not harmless that it should be regulated. It's about time. I know we could give you the stats of, the numbers of people that have now public opinion and whatnot. It's basically now we're at the level of alcohol prohibition at this point. And therefore we ask that you support this bill. We support this bill, and I am available for any questions.
Okay, thank you. Next is Director Snippen with Department of Transportation. Comments. Next is Gary Suganuma for the Director of Department of Taxation. With comments? Yes. Okay, next is Health Resources Administration. Also with comments. Next is Tom Yamachika for Tax Foundation of Hawaii. Supposedly on, oh, I'm sorry, you're here. Oh, yeah, I did. Yeah, go ahead.
Good morning, Chair, Vice Chair, and members of the committee. Michelle Nakata, I'm the Chief of the Office of Medical Cannabis Control and Regulation, representing Dr. Kenneth Fink of the Department of Health. The department does stand on its written testimony, commenting on our significant public health concerns regarding potential impacts that we foresee will come with legalization. I did want to make one comment. There's an error in my testimony in the offered amendment at the bottom of page 4 in my testimony. The language should read personal use shall be prohibited, and what we would like it to say is any location where the consumption of alcohol or smoking is prohibited. The written testimony that I submitted said and we would like the wording to be or. Other than that, I'm available for any questions. Thank you very much.
Thank you. Next is Tom Yamachika for Tax Foundation of Hawaii on Zoom. Is he there? No, okay.
Currently on Zoom, Chair.
Okay, he has comments. Ira Cicada, Commissioner of Financial Institution, testifying for the Division of Financial Institutions at the Department of Commerce and Consumer Affairs.
Commenting on the lack of banking access.
Commenting on the lack of
Banking access.
banking access. Okay. Next is Chris Caulfield, Executive Director, Imua Alliance. Comments. Archie Cole, Mothers Against Drunk Driving. Also with comments. May Pui Mao No Poi, Miley Cannabis Clinic.
That's me.
Okay.
Sorry.
Come on up. Good morning.
And you can
Good morning, Chair Rhodes and Vice Chair Gabbard. Thank you for hearing testimony on this matter. I'm a family nurse practitioner and a certifying clinician in the state of Hawaii. I'm here to stand in opposition of this bill. This bill is not a legalization bill. This bill is a commercialization of cannabis bill. I think that when we look at the illicit market, the black market, the bad people, that's really like our community, that's our neighbors, that's our aunties. And this bill really is not created for them. Making access only available from the dispensaries while allowing a modest amount, 1 ounce of cannabis, is going to have effects that we cannot foresee at this moment. I am pro cannabis, pro legalization, but in a way that actually supports our community. So we recommend increasing the amount of decriminalization first, from 3 grams up to what this provides, 30 grams, when we're looking at social justice. And also looking at small businesses instead of large businesses when it comes to cannabis, so we can really bring the people in our community who've been doing this for decades, who have been criminalized by the war on drugs, into this industry. So thank you.
Thank you very much. Next is Jacqueline Moore for Big Island Grown. Good morning.
Good morning. Jacqueline Moore, CEO of Big Island Grown Dispensaries. Big Island Grown stands on this written testimony, and I'm available for any questions. Thank you.
In support. Okay. Jason Hanley, Oahu Cannabis Farms Alliance.
Getting hypothermia back there.
It's cold up here too. Good morning.
Oh, good morning, legislators. A lot going on with these cannabis bills. There's a lot of them coming through, and so I'm going to give you my comments. I've been following these bills for about 10 years through other states and through Hawaii as well, and trying to come up with the right answer. So I'll just read you who I am.
I'm sorry, Chair, could you state your name again?
Yes, my name is Jason Hanley.
With?
Yes. I'm a retired 20-year federal biologist for invasive species through the U.S. Fish and Wildlife Service here in Hawaii. I'm a U.S. Army veteran, but most importantly, I'm the owner of Karawailua. Karawailua is a farm on the North Shore, Mokule'a, with over 1,000 patients. And I'm also a member of the Oahu Cannabis Alliance, whose mission is to create access to safe and affordable medicine for cannabis patients and help build a cannabis economy owned by small businesses and families across the Hawaii. Thank you for your opportunity to speak today. In the last week, the people of Hawaii have been handed hundreds of pages of cannabis legalization bills with little time to review and compose arguments. But there is one clear fact that arises from all these bills. These bills are commercialization bills, allowing only dispensaries to exist in a multi-million-dollar industry. There is no mention of small businesses, jobs, or local reinvestment in the community. The dispensaries are using this legislature to line their own pockets permanently. We oppose SB 669 as written. SB 669 has some great components to start the decriminalization and legalization process. We are all about that. But fails by only allowing one small group in the Hawaii cannabis market to exist and allowing them to control the whole cannabis market with a 2-year special profiteering period written in the bill. We do support an agency being developed with all the stakeholders. We've all been trying to come together, and it's just not happening. People, dispensaries, DOH, we're just not coming together, and everybody's arguing, and we can't figure this out. And there is a way to figure this out. We've been working with a lot of people across the United States on what is the best program to put forward. And so we have a lot of questions we can answer moving forward. Okay,
Thank you
sorry,
very much.
thank you. Aloha, you guys.
Next is Alan Johnson for Hawaii Substance Abuse Coalition. In opposition, next is Eva Andrade testifying for Hawaii Catholic Conference. Also in opposition, Tai Cheng, Aloha Green Holdings, Inc. Followed by Devon Ward, Marijuana Policy Project.
Good morning, Chair. Good morning, Vice Chairs and committee members. My name is Tai Cheng. I'm a president of Aloha Green, one of the
Just 1 second.
Yeah. Support.
Right, go ahead.
No problem. My name is Tai Cheng. I'm president of Aloha Green Holdings, one of the medical cannabis dispensaries here on Oahu. We're testifying in support. We stand in our written testimony, but we have a couple comments we wanted to raise to the committee. One is that we do think it's very important that sales do start on the first day of any type of legalization to make sure that the illicit market doesn't gain a foothold. Once any type of legislation or decriminalization bill passes, we can expect an increase in the number of illicit actors who enter this industry. What we propose in our legislation here is a 329 program without the 329 card. So this is a medical program with the same regulators, with the same strict regulation and rules that have been used over the last 5 years without any problems. This phased approach will allow the legislators as well as the rulemaking authority of the regulator to come up with rules that are custom to Hawaii, that work for Hawaii, instead of just looking at rules from California or New York or Nevada that might not apply to the way that we grow and consume cannabis here in Hawaii. Thank you very much, and I'm available for any questions.
Thank you. Next up is Devon Ward, Marijuana Policy Project. Good morning. Followed by Bill Jarvis, NOAA Botanicals.
Chair. Aloha, Chair Rhodes, Vice Chair Gabbard, distinguished members of the Judiciary Committee. My name is Devon Ward. I am Senior Legislative Counsel at the Marijuana Policy Project, the largest cannabis reform organization in the United States. We've been working with lawmakers for over 25 years to develop most of the cannabis policy throughout the country. And I am a Hawaii resident, and I live here in Oahu. We submitted significant technical comments on the bill and suggested amendments with language. But a few points that I wanted to amplify to the committee is I believe that the time has come for Hawaii to join 21 other states, Guam, and the U.S. Virgin Islands as recognizing cannabis prohibition as a failed public policy. I think the majority of the residents of the state, and likely the majority of folks in this room, agree with that sentiment, although we all may disagree on how we get there. Just a few other comments I want to amplify on SB 669 specifically. My recommendation that the license fee for the existing medical operators to convert to adult use be a significant fee. In other states, that fee has been upwards of 6 or 7 figures. It is a significant business opportunity to give licensing to the existing medical operators without any licensing fee. I also want to urge the committee that if they are inclined to give the existing medical operators the ability to serve adult use customers, that they also require that the operators present a medical preservation plan to regulators to ensure that adequate medical supply is available for medical patients as we convert to an adult use or hybrid system. And lastly, I want to strongly encourage the committee to adopt the social equity and expungement measures included in SB 375, which has been referred to this committee and will be heard by the Health and Human Services Committee and Consumer Protection Committees tomorrow. I stand available for questions. Thank you for your time.
Thank you. Next is Bill Jarvis for NOAA Botanicals. Good morning.
Morning. Chairs, Vice Chair, members of the committee. My name is Bill Jarvis. I'm the CEO of NOAA Botanicals, and we strongly support SB 669. This bill provides revenue generation for the state of Hawaii, increased safeguards to protect the community, and a thoughtful phased-in approach. SB 669 proposes a 10% excise tax estimated to generate $81 million in annual tax revenue. This robust economic activity already exists in Hawaii. However, it's occurring in the untaxed and unregulated illicit market. This bill protects our community. Our current cannabis laws fail in that regard due to the untested cannabis that exists on the streets. Illicit, unsafe activity will be brought into the light of day where it can be regulated and products can be tested for safety. Lastly, SB 669 ensures a phased-in approach to legalization. Many states have an under-regulated and oversaturated market, entirely avoidable with thoughtful and conservative policy. This bill, I believe, is thoughtful, conservative public health policy. And then lastly, I'd like to kind of set the record straight. There's been multiple people testify that this is a bill that excludes others from entering the industry. That's not the case. It does call for new licenses and allows those to be issued. So thank you again for the opportunity to testify.
Thank you. 1 second.
Next up is Mark Barnett from the Maine Craft Cannabis Association. Online, Mark.
Good morning, Honorable Chairs Rhodes and Keohokalole, Honorable members of the Committee on the Judiciary. My name is Mark Barnett. I'm here representing the MCCA. We've submitted written comments that we stand by and also comments during the dual use task force hearing. We'd be happy to answer any questions legislators may have about those. Our members are small cannabis businesses from across the supply chain, including medical practitioners and medical patients, as well as adult use businesses. We have decades of collective experience in legal regulated cannabis markets, and we're a member of the National Craft Cannabis Coalition also. Overall, we believe it's important not to tie commercialization to decriminalization. The latter, in our view, is a much more important policy goal to directly improve the lives of thousands of Hawaiians. We would suggest that we stop putting people in prison and get people out of prison before we line a few dispensary monopolists' pockets. In that respect, we strongly endorse the elements of decriminalization in Part 2, Section A2 and Part 3 of this bill. We think those should be the focus of action right now moving forward. We think that expungement of records could be incorporated into this reform as well. But the business regulation, SB 669, presents some serious problems. We don't believe there's any urgency more important than good policy, so we recommend the state resist calls to swiftly implement a commercialized market that stands to benefit only a few chosen investors. It's a recipe for total regulatory capture. And Part 2A7 explicitly creates a captured market for 2 years, potentially millions of dollars in revenues, giving them a huge advantage on real estate, brand presence, cash position, but also a huge stream of cash to use to lobby to protect their interests, which has happened over and over again, I believe also in this medical program. Further, in Part 2, Section A6B, dual use license, which is only available to those dispensary holders, is the only license authorized to manufacture or transport cannabis. So every licensee, no matter what time in the future, will have to go through those dispensaries for all of their business and distribution and manufacturing. Fair market access should be a fundamental principle for policymaking. So one final suggestion on that is to remove Part 2, Section A8, A3, which would award licenses only to dispensaries. Lastly, we think the creation of an advisory commission is a good concept, but it has to be answerable to a committee of jurisdiction, have built-in review of rulemaking, and be completely free of all conflicts of interest to avoid further regulatory capture.
Thank you, Mr. Barnett. Thank you for your
time.
Thank you. Next is Casey Rothstein from Green Aloha Limited.
Hello, my name is Casey Rothstein. I'm the CEO of Green Aloha. We're the Kauai medical marijuana license. Thank you for the opportunity to testify today. We are a small business. We have less than 25 employees. We are not corporate cannabis. We're locally owned, small business, family owned. I'd like to simply say, let's not let the perfect be the enemy of the good. You're never going to get a perfect bill that everybody agrees on. It's just not possible. People don't agree. There's lots of different opinions of how this should go. This bill is a good start. It is a start that takes a phased-in approach for all the reasons that Bill Jarvis and Ty said. It's a good start. I would hate to see Hawaii go down the path that Ohio went. Ohio had a cannabis bill in 2015. It set up a dispensary program like this. It allowed people to home grow, allowed people to trade, gift. It ended the criminalization and stopped putting people in jail for cannabis. But groups who thought that they were going to be left out of the industry banded together, formed a campaign, and killed the bill. And here we are 8 years later, and Ohio still doesn't have legalization. It still has had thousands of people in the last 8 years go to jail and have their lives ruined over cannabis offenses. And the average everyday consumer who only wanted to be able to just go and buy at the store like a normal person and not feel like a criminal still can't do that, because those people who feared that they might get left out of a market stopped the market from ever coming to fruition. And here they are 8 years later, and they're in Ohio, still a long ways from happening. Now's the time in Hawaii. This is a good bill. It's a good start. Is it the end? Is it the last cannabis bill that Hawaii is ever going to see and ever going to pass? Of course not. But it's a start, and it's time to start. It's time to end the prohibition. It's time to stop criminalizing cannabis. Thank you for your time. I'm available for any.
Thanks very much. Next is Nikos Leverance for Drug Policy Forum of Hawaii. Good morning.
Good morning. Aloha, Mr. Chair, Vice Chair, and members. Nikos Leverance with the Drug Policy Forum of Hawaii. And I just wanted to say how wonderful it is that we are now at a point where we have a governor who supports cannabis legalization. We have bipartisan support of adult use cannabis legalization. And this bill, I think, really represents an important opportunity to move toward that. Some of the points raised by the AG and the Department of Health are very well taken, and some of their input can be incorporated into that. We also think that the Hawaii Substance Abuse Coalition is correct insofar as some of the tax revenues being used to fund not just cannabis use disorder, but also all behavioral health treatment, as well as stabilization beds for those suffering from alcohol use disorder and disorders related to other drugs. We believe that the decriminalization amount in this bill is too small, and it should be increased to at least 100 grams. We're also deeply concerned that there are no provisions for social equity here, and that to the extent possible, we need to incorporate our legacy growers into a prospective adult use economy, including those from our native Hawaiian communities. And finally, we think that there needs to be some level of records expungement for those with cannabis convictions. Cannabis is a driver of our probation population, and our criminal legal system, as we all know, disproportionately impacts our native Hawaiian community. So mahalo to all those who've offered testimony in support of this bill, but we believe that now is a really critical opportunity to kind of come together and to work towards something beyond what is already happening right now. We should empower local producers to enter the market, and we should do everything we can to facilitate small businesses. Mahalo.
Thank you. Next is Randy Gauntz, Executive Director, Hawaii Cannabis Industry Association. Good morning.
Good morning. Chairs, Vice Chairs, thank you for the opportunity to testify today. I'm the Executive Director of the Hawaii Cannabis Industry Association. We represent 5 of the licensees in the state. At any given point, we could take a lap around Waikiki and someone will be offered cannabis on that stroll. And that cannabis is untested, it's unregulated, and it's been happening here in Hawaii for years, generations really. And we have the opportunity today to pass some policy to regulate what happens in the state that's already happening. We know that there's a huge ecosystem of economic activity happening in our state that is currently happening in the dark. And if we bring that into the light, we can capture upwards of $80 million in tax revenue a year. Over 5 years, that could be $400 million. And really the conversation around cannabis can be changed to what can we do for our state with that amount of money? Can we put some money towards homelessness issues? Can we put some money towards healthcare and mental health issues? And we have that opportunity today. I think it's time. HICIA has been around the nation working on this issue. Myself, as a member of Drug Policy Forum of Hawaii, as a military veteran, has used cannabis for decades for my ailments. We have studied this issue for far too long, and all the results are in, and it is time for Hawaii to move this measure forward. Every year that we wait is another year that we have this black market continue to get stronger. You can go into any one of those smoke shops here in town and you'll see Delta 8 products, even Delta 9 products. They have packaging appealing to children, and that's unregulated, and that's appealing to the individuals that are wanting to participate and purchase this product. So we have the opportunity now to provide safe, clean access to this product. And HICIA is here to work with all stakeholders to make sure this bill is something that's palatable for this body to pass this year, so we can start the work that's going to take years to build this industry.
Thanks
Thank
very
you.
much. Next is Alex Wong, Kauai Farm Planning in opposition. Jeffrey Lawrence, Reason Foundation with comments. Greg Tjatkis, Coalition for Drug-Free Hawaii. On Zoom.
You're on Zoom. 1 minute.
Okay. Good morning.
Good morning. Sorry, my name is Greg Chapkus. I'm the executive director of the Coalition for Drug-Free Hawaii, and we are opposed to this, and primarily being talking about the youth vulnerability of the adolescent brain and high THC products that would be resulting from this legalization. We know that 40% of kids already have vaping issues, and 12.5 of them are vaping THC. And we know that this is, it's not legal for them to have any of this. And just because we see there's going to be a 21-year-old threshold does not mean they're not going to get it, because they are going to get it from friends and family, the way they get alcohol from friends and family. There's lots of discussion about revenues here, very little discussion about costs. And I know some of the public safety proponents will tell you that the black market will only increase with this, even as Tai Cheng has mentioned. The illicit market will increase with legalization, and it does not reduce our public safety costs, but there will be more seizures, as there have been in Colorado. Lastly, I think, we're not addressing the impaired driving also, which we've seen increase, almost triple in Hawaii, just after the advent of medical marijuana dispensaries. THC-related fatalities, and that's happened in every legalized state too. I guess that wasn't the last thing. If you look at the Dual Use Task Force Public Health and Safety Work Group report, and also report last year from HACDAX, the Advisory Commission on Drug and Alcohol Abuse, they both recommend potency limits, evidence-based prevention and prevention education for youth, and a number of other safeguards there to protect the youth and protect the public.
All right, thank you very much. Next up, we have Frank Stiefel, Last Prisoner Project. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. My name is Frank Stiefel, and I'm testifying on behalf of the Last Prisoner Project, which is a national nonpartisan nonprofit focused on cannabis-related criminal justice reform. I'm testifying on behalf of LPP to urge the members of this committee and the rest of the Hawaii State Legislature to ensure that SB 669 include a state-initiated record clearance process for cannabis records, as well as guaranteeing the reconsideration of cannabis-related sentences through a state-initiated resentencing process. We believe that implementing a commercial market for cannabis is not the full picture when it comes to legalization. The state must also develop processes for retroactive legal relief with broad eligibility for those criminalized by prohibition. These processes must also be state initiated so that individuals who are eligible are not left behind. Over the course of this last year, the Last Prisoner Project worked with members of the Dual Use of Cannabis Task Force to outline evidence-based policy recommendations for inclusion in any legalization proposal to ensure retroactive relief for those who have been criminalized by prohibition. The task force's social equity working group fully embraced LPP's recommendations for the creation of a state-initiated record clearance and resentencing process, endorsing them in their official report. Unfortunately, none of these recommendations that the social equity working group that they endorsed were reflected in SB 669. We believe that in order to adequately address the past harms of cannabis criminalization, SB 669 must outline legislative avenues for retroactive relief through state-initiated record clearance and resentencing processes. We believe this can be actually achieved by including language from SB 375, which outlines the creation of a state-initiated record clearance process. Language could also be taken from SB 1043 to ensure that a resentencing process is also created once the state legalizes adult use cannabis. Thank you for your time, and I'm more than happy to stick around to answer any questions.
Great, thank you very much. Okay, the remainder of this page, we have 3 individuals in opposition. Next page, we have Tricia Mills. Good morning.
Aloha kakayaka. My name is Tricia Mills, and I appreciate the opportunity to come and oppose Bill 669. I've been a 329 card holder since November of 2010, and I'm asking that you please don't tie decriminalization to dispensaries' profits. Release people from prison first. This bill will threaten the medical program, as the dispensaries will immediately shift all their focus on adult use away from the patients. The license types are designed so that dispensaries control everything. All other licenses will have to go through them. This bill does not support local cannabis jobs and small business licenses for the people of Hawaii. Mahalo for your time.
Thank you very much. Let's see. We have Chad Miller. Good morning.
Good afternoon, committee. Thank you for your time. And I'll get started. I oppose SB 669. It has many great points protecting patient rights and decriminalizing cannabis, a plant-based medicine alternative for the people of Hawaii. However, the introducing and backing parties originating this bill are for their own vested interests. This should be very clear to you folks of who owns these, as well as other large monopolized industries in this state. I grew up out here as a kid and saw this time and time again. I also left this state to participate in cannabis because this state was the first to legalize medical cannabis, but the last to do anything to provide access for 16 years for people and still criminalize those people trying to get their own medicine. The small print and details of this bill all continue to stack the cards in favor of current license holders and put more control in the hands of the overwhelmed and uneducated DOH. This vertically integrated market has failed our community and our patients. The people of Hawaii deserve better, and we have seen examples of failed states doing this and shining examples to observe and follow states that will benefit not only our state, but the people of Hawaii. From the failed approval of our testing labs in this state, which should be noticed and documented. We never should have had a program. This is flat out wrong and a misuse of the term. Remediation was introduced by the DOH in order to put more products that were originally failed back on for medical patients to consume. They are using a term called remediation, however, not checking for residuals for ethanol extraction. We have documented facts showing and documenting that that is wrong and not tested for in this state. So nothing against them. That's how they're operating. We have no testing for residuals, ethanol extraction, and no testing for residuals. Nurses Act.
Thank you very much.
Thank you.
The next page is, looks like 22 individuals opposed, 9 in favor, and 1 with comments. The next page is mostly in opposition, some in support. And then we have 460 individuals in support with a form letter. The testimony has been received. So if you're one of these people, one of the people who submitted this, testimony has been received and will be posted as quickly as we can process it, but it's not all up yet. Okay, that's everybody who signed up for SB 669. Anyone else here wishing to testify for or against? Okay, let me go 1, 2, 3, 4. Yeah.
Good morning, committee.
Good morning.
Chair Rhodes, Vice Chair Gabbard, and the rest of the committee. My name is Joni Kulika Kaihapo. I have been a resident of Hawaii for the last 30 years, grew up here. The marijuana program is very important to me. It has helped me be able to step up here. The use of opioids would not allow me to talk to you like this. I am in favor of decriminalizing medical marijuana, but I am opposed to SB 669. We need to have move this away from commercialization. We need to make sure that it is economically sound for the people here in Hawaii and take care of the patients. Thank you.
Thank you very much. Let's see, I think it was Ms. Nakamatsu like that. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Deputy Prosecutor Tricia Nakamatsu appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in strong opposition to the bill. I apologize for not submitting written testimony earlier, but we will do so. In December 2022, the Dual Use Cannabis Task Force, which was actually created by the legislature, submitted its report to the legislature and specifically declined to adopt specific recommendations for moving forward with, at this time, to move forward, and instead made recommendations unanimously to establish targeted task forces and working groups that would then proceed to flesh out a number of specific policy and procedures that we feel are important, as a task force felt are important, to formulate a safe path forward for legalization. Seeing the contents of SB 669, the department is greatly concerned that the bill would rush to open doors to legalization without having a suitable or workable, comprehensive plan to account for the numerous issues that we know will arise with legalization of cannabis. We do have the benefit of seeing how other states have handled it, not the least of which could be the influences of quote unquote big marijuana that are of great concern. At some point, as we've seen with big tobacco, science somehow takes a back seat to profits or tax revenue. Public policy issues such as health and safety are of utmost concern to the department. And we see that these are directly related to potency, which has on the continent ranged from about 17 to 20% in typical THC levels, and as high as 95% for concentrates, all of which can be related to a number of increased emergency room visits, traffic crashes, fatalities, the list goes on. Lastly, I'd like to point to a 2022 report that was actually put forth by the Hawaii Cannabis Industry Association, which indicated that 69%
Thank you very much.
of users aren't actually
Okay, ladies and gentlemen, we're supposed to be out of here already. So members, I would like to vote on the bills that we've already completed, and 669 we'll have to deal with later. If that's okay with you, we'll go into decision making for the, I guess it's two bills that we've already. Right. Okay, seeing no objection on SB 495 relating to building codes, this would extend the time each county has to amend and adopt the Hawaii State building codes from 2 to 6 years. It's a can of worms. I don't see a way forward at this point, so I'm going to defer it indefinitely. The second bill was SB 977. Relating to the judiciary, the proposed SD1 allows for judicial review of orders fixing minimum terms of imprisonment, and it specifies that in any civil actions brought by the petitioner under Chapter 661B, seeking compensation of any kind or nature whatsoever as a result of related to or arising from a conviction or imprisonment, the total award made in the civil action against claims or asserted will be offset by the 661B claim. Okay, thank you. On this one, the testifiers convinced me that the direction I was headed probably is not. It's thinking back yesterday to Senator Keith Agaron's opening statements on the floor. I think this one is, the first part is half baked at this point. So I'd like to move it forward with the committee's indulgence, but I will put a defective date on it, and so we'll adopt the proposed SD1, but we'll also add a defective date of March 22, 2075, and we'll see if we can. It doesn't feel to me like the interested parties are that far apart, but I don't have the magic language yet. So, questions or concerns? If not, 977 with amendments.
Chair's recommendation is to pass SB 977 with amendments. Of the members present, are there any no votes or reservations? Hearing none, the measure passes.
Okay, thank you. So those are the two that we finished. Now I would like to go ahead and continue what we have until, we're told until we have until 11:15. I don't know, do we have caucus today? Does anybody know?
No caucus.
No. Okay. we have until 11:15. Let's try to finish up the testimony on SB 669. I don't know if we'll get to questions or not. So there were two other people who wanted to speak. I think you were first, and then in the middle here. Good morning.
Aloha, Chair, Vice Chair, and the Judiciary Committee. My name is Angela Melody Young, testifying on behalf of CARES, providing comments. This measure seeks to decriminalize marijuana in order to regulate it. However, there are federal regulations. Marijuana is strictly regulated and may not be legally used for medical or recreational purposes unless the research gets approved. DEA recently eased some of the regulatory burdens so that researchers can conduct FDA-approved clinical trials on CBD, an extract of the marijuana plant. These modifications will streamline the research process regarding CBD's possible potential medicinal value. Growing plants and supplying for medical studies is okay if it's within the FDA parameters of clinical trials. This substance should only be accessed for those with cancer or for those who are ill. However, outside of research and clinical trials for medical studies approved by the FDA, cannabis is a Schedule I substance. The DEA, the U.S. Drug Enforcement Administration, classifies marijuana as a Schedule I substance because it has a very high potential for abuse and little to no medicinal value. When people abuse cannabis, it results in gang activity, addiction, debt. It's a gateway to other substances. And the DEA says and then there's Schedule II, right? So the DEA says Schedule II substances have some medical value, while Schedule I has no medical value. So Schedule I receives more regulatory scrutiny because of the high potential of abuse, even though it's not dangerous. For example, cocaine is a Schedule II, although cocaine can be seen as more dangerous than marijuana. So the FDA, the DEA administrator, and the AG works together on this matter. So, if people want to use marijuana for medical research, they should petition the DEA and FDA. Those who have developed medical research can petition DEA to reschedule cannabis or to get an approved trial. And the petition is for anyone, the manufacturers, the medical society, individuals.
Thank you very much.
Thank you.
Gentleman in the blue, you're next if you want to go. Good morning.
Chair, Mr. Chair, Ms. Vice Chair, and members of the Judiciary Committee. Aloha. I oppose this Senate bill. Sitting there reminded me of 50 years ago. And that time it wasn't commercialization and legalization. See, my uncle there, Kupunas before, in Kona, they used to grow, and that was the extra money. The extra money for travel, for do all these different things. And then the wasn't businesses that time, was National Guard. Green Harvest came in, took that all away 50 years ago. And today I see the same thing going on in here, in a different light, trying to get this going for, economic reasons. And at the same time, it's taken away from, really one situation that's going on in our community. I don't think the Hawaiians ever came out and talked about this, but there was a way of exchange. And if this happens and the commercial guys control this, you can get more problems in the future because they're not going to stop. All people are not going to stop. What may be a paycheck to these guys is if I give my nephew or my niece, a quarter ounce or something like that, that's going to be wrong too. We never had problem with pesticides and all that kind before. We never had that problem. So when I hear people talk about, well, we got to test them because of this and that, yeah, I can see why. Today's world, with all the things going on this earth. But I definitely don't want to see that happen again. I can't see that.
Thank you very much.
Okay, thank you. Aloha.
Aloha. Anyone else wishing to testify on SB 669? All right, come on up.
My name is Loretta Black, and I help.
We can't hear you if you don't talk to the mic.
My name is Loretta Black, and I help at one of the farms here, Carraway Farms. But did anybody ever ask me what was right for me? Did anybody ever ask the patients walking through our place what is right for them? I oppose this bill strongly. I have my own medical problems. And I've tried all the medicines in the Noah Botanicals and the cure. Honey, I had your owner of Noah Botanicals in my farm 2 weeks ago, trying to get a growth site change. So the sheep and the wolves, they're all eating together right now. And I'm highly upset because the medicine that I use for my pain don't come from the dispensaries because I've tried it. It don't work. I gotta make my own little medicine, and if taking some coconut oil and a bud in a jar, mixing it together, rub it on my face is wrong. I highly oppose this bill. It's not right for the people. I'm with the people every single day. I'm the face of the people. I'm the voice of the people. How can you guys do this to us? You guys want to legalize a bill? In my neighborhood? I don't have nobody dealing drugs in my neighborhood that we know of. But as soon as this bill comes to light, they all come out of the woodwork. I have daughters. I raise daughters. I have to protect my children. I have to protect my grandchildren. Are you guys kidding me right now? You telling me that I cannot make my own medicine from two little God-given things to help me with my pain? Periodontal disease? I work with the people every single day. Maybe you guys need to ask me some questions. Thank you.
Thanks very much. Anyone else wish to testify on SB 669? 669. Okay. Oh, you have your hand up? Yep, come on up.
Good morning, legislators.
Good morning.
I'm Anthony Faree. I'm a baker. I'm a disabled veteran, and I have, over the past 10 years, I've had disabled veterans that didn't want to pollute their lungs because they were Vietnam veterans. They were in their 80s. So I helped them with medical marijuana in baked items. And I was approached by the wife of a disabled veteran to help her husband. How can I say no to that? And I was so relieved when Wailua Farms came into existence. It's more affordable. It's not intimidating. I've had veterans tell me that they don't like the dispensaries. They feel like they're on camera. It's like all sanitized environment. Whereas at Wailua Farms, it's comfortable. It's an outdoor environment. It's relaxing, and they don't feel intimidated. And there's knowledgeable people that get them the type of medicine that they need, and it is medicine. And it's really disappointing to me that opioids is something that I've helped 4 or 5 veterans get over with the use of just some good cannabis as a replacement for their medicine. And I like to think that I've saved a few lives just because of medical marijuana. And if they say it's a class 1 illegal drug, I don't care what the feds say. I'm not going to say no to my Vietnam veterans when they need some medicine to overcome some ills. And when grandpa gets his ass off the couch and he's taking the kids fishing again, and the grandkids are happy grandpa's not a ball of pain on the couch, that's a victory in my word. And so I hope that you don't interfere with the access that my disabled veterans have to their medicine. Thank you for your time.
Thanks very much. Anyone else wishing to testify on SB 669? Okay, so before you start, come on up. I'm just before you start, members. Is there anybody else who wants to testify? Okay, you'll be the last testifier, and then for the bills that we did not finish up today. So this bill, 179, 182, 805, 197, 226, 228, and 719. I believe that's all of them. we will go ahead and roll over until Thursday at. We already have I think we're gonna have to go earlier. Let's go for 9. Okay, so we'll roll over till 9 on Thursday, which will be the 16th in this room 016, and we'll post a notice. We may actually have to post 2 because this will be a continuation, and the other ones will be taking testimony. Okay, you get the last word.
Yes.
Go ahead.
Good morning, and thank you for having me, members. My name is Gerald Mills. I'm married to this wonderful lady who came up earlier, my wife Tricia. She's been making medicine for me for probably, at least 10 years. I use a topical for my arthritis, and I use almond oil for my skin. These are items that I feel are very dynamic in the use of arthritis pain, and the skin oils are marvelous for, I've had skin cancer. So the point I'm making is, as a small mom and pop, if you will, we love growing our own medicine. We find that it's very therapeutic mentally just to even be around a few plants. I am opposed to this bill, mainly because I don't like the fact that you want to reduce the number of plants we can grow. That to me is, that's just not, you don't give people something and then take it away and expect them to be happy. So, the point I'm making is, everybody's talking about revenue. This is America. We can throw enough money at anything, and eventually the problems will go away. Well, that's not a fact. It's not. The revenue could be beneficial for many things. But as far as people like us having to go to dispensaries, showing identification, leaving our phones outside, things of that nature, that's not a friendly environment as far as I'm concerned. And, that's all I wanted to add. Thank you for your time.
Thank you very
I
much.
really do appreciate it.
Thank you. Okay, so for the 9:40 agenda, I guess technically we're recessed until 9 a.m. on Thursday in this room here, February 16th. Recess.